I'm delighted to have here with me today Robert Mackenzie, who is a barrister specialising in legal representation in connection with commercial litigation matters. Robert, how long have we known each other for, would you say?
Getting on for 5 years, I think.
Some splendid 5 years those have been. We've produced some fantastic results for our clients. Now, in terms of how we produce those results, there's a bit of a partnership, would you say, between me as legal executive preparing for the court hearing. So I prepared a bundle, the witness statement and the evidence.
Yes.
I then send you the same in the post, because you want to get everything, all the originals. What do you then do with the bundle when you receive it, Robert?
Well, once I've opened it, I read through it, and I read through it thoroughly so that I can be prepared for going to court, and so that I know what's going on. I know what the questions are, I know what the issues are, and know what all the detail is.
Okay.
Because a case, Carlo, is not won in court, it's won in preparation. And you want to turn up to court, I want to turn up to court knowing everything there is to know, so that any judge can ask any question.
So the old adage, if you do not prepare to fail, is, you would agree with that?
Yeah.
Court hearings.
Mind you, even with all the preparation in the world, you can still lose.
Yeah. But at the same time, what I forgot to mention, not only do I send you the claimant's bundle, because of course the directions will order that we would have had the defendant's bundle by the time that I send the bundle to you 14 days prior to the hearing. So you would have also have had the opportunity to look at the defendant's bundle and their witness statement. Yeah,
absolutely. You need to know what the defence is saying. And in any bundle, there is, or there should be, the defendant's case as well.
Okay.
And not so much in small claims, but in bigger claims, the issues which are going to be important at courts are known in advance.
Okay. Okay, that's through disclosures, is that
through
right?
Through disclosure and through such things as having to give an issue statement, a statement of case.
Okay. So you put quite a considerable amount of time into the preparation.
Yes.
And what does that involve, other than reading? Does it involve skeleton arguments?
It can do, not so much in small claims, although I think a judge always likes a skeleton argument.
Okay.
A good skeleton argument, which tells him what he or she needs to know. But it's understanding the case, and it's understanding what might potentially be pitfalls in the case and pitfalls in the defendant's case.
Now, I certainly know for our cases you make a habit of producing a skeleton argument, which you deliver to the judge prior to the hearing. Do you think that that's been a very useful tactic, if that's the right word to use, for the small claims hearings which we've had? I don't think there's one small claim hearing we've lost, to be honest. I think we've won all of them, haven't we?
So far.
Would you touch wood? And would you say that comes largely to the preparation?
Yes.
And the advantage of presenting a skeleton argument, although you don't have to in small claims.
Of course not. No, you don't have to in small claims. In multi-tracks, you do. And I think fast track will depend on the order. But in small claims, you don't. But if you're a judge, in a district judge, in somewhere like Edmonton County Court, and you've got a busy list, which will probably involve about 5 or 6 trials that day, or listed for that day, then...
And that day, sorry to interrupt, that day starts from 9 a.m.
Yeah. The first hearing will be at 10 a.m, except for emergency hearings, like warrants, applications and so on.
Right through to 5 in...
Well, officially court closes at 4:30. But if in the middle of a case, it will go on to 5.
5 small claims hearings between 9 and 4:30,
Absolutely.
10 and 4:30, I should say.
Yeah.
The judges are stretched.
They are, and which is why a good skeleton argument, which is very brief but tells them what they need to know, is invaluable. And I've been, in your cases, I've been thanked by the judge on a number of occasions for the skeleton argument.
We've had complicated cases.
They are. That's the trouble with small claims. The actual issues involved, both legally and in terms of facts, can be just as complicated, if not more complicated, than a multi-track case. But of course, the damages are limited to 10,000. So the preparation can outweigh the reward, in essence.
And going back to what you said earlier, with small claims hearings, that judge has got usually five small claims hearings listed on that day. What also impresses me about your skeleton arguments is that you do read the case law.
You have, yeah.
And how do you do that? Do you go to? Have you got a library that you go to?
Yeah, there are four inns. I go to a library, often one of the Inns of Court libraries.
Yeah.
Of which there are four: Lincoln's, Gray's Inn, Middle Temple, and Inner Temple. Each with their own law library.
Yeah.
But you've got to know the law, because
that's not just legislation.
It's
We're
not
talking
just
about case law as well, isn't it?
Case law.
But do you agree that case law often wins cases more than... Because legislation is legislation. You then need to look at the cases to interpret what the legislation is.
There is a rule of precedent in this country, so judges are meant to follow the last decision. So case law is very important, and there can be... One always wants to check up the case law before you go into court, because there could have been a decision the previous week which overturns our case or is very much in favour of it. But again, it's just an example that it's preparation that wins the case.
In terms of the cases that we've represented, have the judges paid attention to the case law that you've put in your skeleton argument?
Yeah, they have to pay attention to the case law and the law, but it's incumbent upon the advocate to put that to them. Okay. Because if you don't...
That's where the legal representation comes into
play. And this is why legal representation, even in a small claims court, is a very good idea, because judges have a tendency nowadays to, dare I say, make it up as they go along.
I think it was the recruitment case where the judge was overwhelmed by the paperwork and the complexity, and the judge asked you to go outside and narrow the issues down.
Yes, she did, but she knew what the issues were because she had read my skeleton argument.
Fantastic.
But even so, there were very complex issues, and the time allocated, of course, was only 2 hours. But the issues probably involved a day or 2 days. But because it's small claims, one of the what do you call them? The overriding objective, one of the elements of the overriding objective, which is proportionality, come into play.
Yeah.
Now, the courts are overstretched as it is. They're closing down all over the place. So for a claim which involves no more than 10,000, and usually say about 4 or 5,000,
which this one did,
they're only going to allow an hour, 2 hours. So in a way, it's summary justice.
If I remember rightly, the judge said, if you can't narrow the issues or decide on it, I will make a decision, or something along those lines.
Yes, well, I think we narrowed the issues, but we couldn't agree to a settlement, and we went back into court, and of course we won.
Because ultimately, all our cases are business-to-business matters.
Yeah. And
in business-to-business matters, correct me if I'm wrong here, Robert, the judges take a laissez-faire approach, which is this is a business-to-business matter. There's an equality of bargaining power here, so to speak. Therefore, I will make my decision based on what the contract stipulates.
Yes.
And I will stand back.
Yes.
So that was what happened in this.
It was, yes, and in another one we've done where the contract, it was with the same company, which will of course remain nameless.
Yes.
But the contract was pretty unfair.
It was onerous.
Was very onerous on the defender.
And the judge even commented that it was onerous.
Yeah, but because it was business to business, the judge couldn't do anything.
And the judge pretty much said so.
And she did say so, yes.
It was a pleasure having you in today, Robert.
Thanks.
An education, some fantastic information you've shared with our viewers. If there's anything in this interview of interest to you, please do get in touch. Our telephone number will appear at the end of the video. Remember, please like, comment and subscribe.